They say they never received my file. That was the forum post. 5 words and a whole life on hold. A child waiting for a residency card. A job offer at risk. Months of calls that go nowhere. Welcome to Portugal Rights Rebel. I'm Elena Vargas. In 10 minutes, you'll know the essential difference between silence that helps and silence that hurts, the first 3 actions to preserve your rights, and the exact wording to put in a registered notice so you can stop guessing and start acting. Here's the legal truth. Silêncio Administrativo is not just silence. The law treats it as an outcome. Sometimes silence counts as approval. Sometimes it counts as refusal. That distinction decides everything. Quick question. How do you tell which you have? Start with the rule that governs your application. Look at the law or regulation cited on the form or the agency website. If the rule says silence equals tacit approval, great, but you still need proof of timing. If the rule is silent, assume silence is negative and act fast. Small tip before we get procedural. Write down the moment you notice a delay. The date you start the clock matters. Now, let's walk the playbook. Short steps, plain language. Step 1. Timestamp everything. Send a registered CTT letter with return receipt. Email the official platform address and keep delivery or read receipts. Take screenshots of submission confirmations and payment receipts. Save platform logs and any auto replies. Step 2. Set a short, firm deadline in writing. 10 working days to confirm receipt and provide a status is a practical default. Put application reference numbers, dates, and the exact request in the letter. Example line you can adapt. Please confirm receipt of the submission dated date, reference number, and provide the procedural status within 10 working days. Step 3. If you don't get a reply, escalate the right way. File a recurso hierarchico, a hierarchical appeal, where available. Or, if the timeline is tight, prepare an administrative court action in the Contencioso Administrativo and consider medidas cautelares to preserve your situation while the case is decided. Curious? Which route is faster? Often the hierarchical appeal is quicker and cheaper. It gives the administration a last chance to correct an error. Courts are powerful, but slower and costlier. Use the hierarchical step strategically, not as a delay tactic. Deadlines vary. Some appeals are 30 days, some 60. Judicial windows can be shorter. If in doubt, assume the shortest time and act now. Missing a deadline can close doors you didn't even know existed. What evidence matters most? The short list. Registered mail receipts, platform screenshots with timestamps, email receipts, payment confirmations, ID documents, and any official reference numbers. Add anything showing harm, flight cancellations, hotel invoices, pay slips, school enrollment docs. Keep originals and create a dated digital folder. If an official told you on the phone that there's no record, ask for that in writing. If they won't provide it, note the date and time and request an email confirmation. Sworn witness statements and employer letters also help when claiming damages for delay. How to brief a lawyer without wasting time or money. Book a 30-minute paid intake focused only on classification and deadlines. Ask for a fixed fee for the immediate filing step. Use limited scope representation where possible. Lawyer files the appeal or medida cautelar, you gather documents. Good lawyers will give you a clear checklist in 1 page. 2 quick cases so this stays real. Case 1. Tacit approval worked. A family had platform timestamps, a registered receipt, and an email read receipt. Their lawyer sent a hierarchical appeal plus the 10-day notice. The administration admitted delay and classified the silence as tacit approval. Cards issued in 6 weeks.
Case 2. Someone assumed silence meant approval and waited. No registered notice, incomplete logs, and by the time they noticed, the judicial window had closed. The option to seek compensation or provisional relief was much weaker. Lesson: documentation and early action matter more than optimism.
I know this is tedious, but it's the difference between a fix and a dead end. Now, the legal warning you must hear. This episode is practical guidance, not a substitute for counsel. Portuguese administrative law has technical rules. Confirm classification and deadlines with a qualified administrative law attorney before you file anything major.
Immediate action you can take in the next 48 hours? Go to the episode page and download the registered notice template and the evidence checklist. Then send that registered formal notice to the competent authority with the exact reference numbers and a 10 working day deadline. Do it now. Don't let another day slip.
If you want a vetted lawyer referral, use the contact form on our site and request a Silêncio Administrative intake. Ask for a 30-minute deadline-focused intake and a fixed-fee quote for the immediate procedural step. Remember, don't accept "we don't have your file" as the end of the story. Document, notify, appeal, and, when required, seek provisional relief. Turn bureaucracy into accountability. Your rights don't disappear at the border. The system is slow. Your preparation shouldn't be. Knowledge is your best defense. Document everything, act lawfully, and protect your future. Always consult a qualified Portuguese lawyer for your specific case. Thanks for listening to Portugal Rights Rebel. I'm Elena Vargas. Your rights don't disappear at the border.